And in studio right now, we've talked about this trial a lot. From the prosecution, of course, we have Scott McNamara. Good morning, Scott. Get everybody's mics live there. Good morning.
Good morning, Bill.
You braved the weather to make it in here this morning.
I almost didn't make it.
Believe me, I have to tell you, as I was leaving this morning, I don't ever brush my car off. I'm one of these let motion do the trick. But I'm out this morning. I'm warming up the cars. I brushed off my wife's car. I'm shoveling. It doesn't look that bad till I got on the arterial to find I'm behind 3 plows all working in tandem at 20 miles an hour all the way. Yep. That'll slow you down. But it was far safer than it would be had they not been in front of me. Also in studio from the prosecution is Stacey Pelosi, Laurie Lisi, and Mike Coluzza. Guys, good morning, and thank you all for I just ask if you can get as close as you can to the microphone. Literally pull it up close to yourselves and even lean in a little bit so I get everybody on. So, can I start with you, Scott? And
sure.
Because your concern, and you tweeted out, and I tweeted back, and we talked.
I wasn't mad at you. I just think that sometimes part of my job is to defend the victims and, more importantly, defend the surviving victims in homicides. And I just felt that based on a lot of stuff that had been going on, that it was important for people to understand that we have a grieving family who lost a loved one. And that's really what I was getting at. I wasn't mad at anybody.
And I do have to say that this is a unique case because it's not every day a case is tried here locally where you then have a Dateline special that comes on and throws out, well, yeah, this is what the jury came up with, but here are some other possibilities. It's not every day where you have the family coming on and saying, the jury got it wrong, and here's who we think did it. It is a unique case, one that we really can't avoid, even though I'm sure that, but on the other hand, I understand. You have family members out there, and at the end of the day, Adam and Bill Yoder are innocent.
Exactly, and you know, there's about as much evidence that you killed Mary Yoder as there is that Bill killed Mary Yoder. So when I hear people talking about all of this stuff, and especially this alleged affair, it just isn't true. And we spent a lot of time investigating that. And there's certain things that are not publicly known. But for example, the lady he was dating, Kathy, dated another guy that looked a lot like Bill. So there's an easy understanding how there could be confusion by some of these witnesses. We have Bill's cell phone. We know what the text messages were before Mary died, and we know what they were after. And without going into gory detail, there's a lot of text messages after he became involved with the sister that would be totally indicative of that's when the relationship started. Right. And the text messages before are very innocent, you know. Hey, where did you get that grill? Because I like the grill. Yeah. I mean, it not like, hey, hey, I had a good time today. And, so there's a lot of that stuff. But there's no evidence whatsoever that Bill had any relationship with any woman that we found.
Okay, so let's start with the prosecution, and we'll start with Mike Coluzza. Mike, what about the private investigator that came forward and said, I interviewed 4 people that said the relationship went back even 6 months beforehand. Had 4 people that then he believes someone got to and they changed their testimony. Does anybody want to pick that one up?
Laurie would be best.
All right, Laurie, I got to have you dig right in there. Laurie, I don't read body language often, but if I were to read yours, it's you're not pleased.
I'm not.
Okay, so you got to get up close to the mic, though. If you just pull that, there we go. That's a little better. Go ahead.
What do you want me to address? What I'm not pleased about? Or
well, we'll
the
start with
question
that.
you
Let's
posed?
start with that, and then I'll pose my question.
I'm not pleased with you.
Okay.
I'm not pleased that you have this forum and that you went on this forum and you put out there that, in your opinion, based on the information you have, which in my opinion is nil.
I'm sure you feel that way.
That Kaitlyn Conley is innocent.
Do you I guess I would say.
I guess my question to you is how many? No, let me finish. How many days did you spend at the trial? how many pieces of evidence did you look at?
Right.
And how much testimony did you hear?
Do you feel I'm not entitled to an opinion?
You're entitled to an opinion.
But I should just keep it quiet.
Well,
Do you feel that the family is not able to come forward? Do you feel I should turn them away when they ask to come forward? Family on both sides. Should I turn them away? In America? Answer that question.
Well,
let's be fair. Answer that question. Should I turn the family away?
I don't have a problem with you having the Conley
So
family.
I just shouldn't give my opinion.
Well, it's based on
Now can you read my body language?
I can read your body language.
Good. So the two of us have a relationship going on here.
No.
That isn't pleasant. Everything's a relationship. Whether it's good or bad, it's a relationship. We have one going right now. So I feel we are entitled to an opinion. I could very well have been a member of the jury. The jury, they don't have a legal degree.
No, but they heard the evidence.
I understand that, but you have family members who came forward. I believe they deserve the right to speak.
Okay.
And what about the investigator who spoke firsthand with these people and said, I had 4 or 5, in some cases, that were coming forward, 4 or 5 that said they saw the two of them together. And you're saying that is not accurate. That testimony is not accurate.
I'm saying I haven't said anything yet about that.
All right. Well, here you go.
But our investigation, we had access to in some cases, a couple of those witnesses gave sworn depositions. One of them called me right after she had given the statement and said, look, I just had a conversation with my husband who said, you didn't get it right. You forgot about the other guy that we saw her with during this specific period of time. And when Chris Pelly went to see this woman, she then tried to correct him and tell him, look, I don't know. I can't tell you with any degree of certainty when it was that I saw the two of them together. But I can tell you that in early 2015, based on what my husband advised me of, and based on my recollection of seeing this dog in the backyard, she was not with Bill Yoder. She was with another gentleman.
Okay. I want to bring in Mike Coluzza. Michael, good morning.
Good morning, Bill.
We do have somewhat of a relationship. And if you pull it just to the point, you literally have to be touching it.
Sure.
Answer the. Let's go down that same road. The private investigators. You have a private investigator coming up and saying, "Don't agree with the verdict." You have family members from both sides, which is unique from both sides. In some cases, that don't even know Kaitlyn Conley, but still don't believe that she did it.
Okay.
And then you have a Dateline special, and Laurie, Lisi, if there's anyone you should be upset with, it would be Dateline, who sensationalized this to the point where they took things out of order and moved things around to create a drama that was more like a Lifetime movie than it was really a documentary. Is that fair?
We were unhappy with the Dateline special. In watching it, I became increasingly concerned as we got to almost the 2-hour mark, and they hadn't talked at all about the second trial.
But they almost like they forgot to finish it.
Upon which the conviction was based.
Yeah.
You know, Bill, I think one of the issues that strikes home with prosecutors is this: that we live in a country of laws, and we give full faith and credit to jury verdicts. And both sides get a say in who sits on that jury. The prosecution has a burden of proof. They have to come forward with sufficient proof. The guilt beyond a reasonable doubt standard is a high standard. There are appellate remedies available. And what happens, I think, when people come on and say, well, I just think that she's innocent. Well, isn't it awfully suspicious that X, Y, and Z happened? Is how are we supposed to receive that information? Are we supposed to take 200 years of American jurisprudence, throw it out, and say, well, let's have a public referendum, and that will trump a lawful jury verdict? We have to give full faith and credit to the jury verdict. Which, hey,
if you want to have a public referendum, I'm your guy. We can organize and get this going. Do you have a
Sure. Let me ask about something that Mr. Policelli brought up on the program, and there were kind of his version is a little bit different than when we talked to Scott. The digital evidence on the phones and the laptops. There was a point in the trial when he was questioning how you could trace where it came from. I believe one of the witnesses went back, I think, over a lunch break at request and was able to track down some of this information. Do you guys ever have any question about where the email address was accessed, where it was ordered as far as devices, and who had access to those devices?
No, there's no, from all of the devices.
And by the way, can I just say, I think I got your name wrong.
Okay.
Stacey Scotti, is that correct?
That is
okay,
correct.
Stacey,
Okay,
I'm
thank
sorry.
you. I mean, over 28 devices were examined. And as far as the digital evidence, it came from all parties, from members of the Conley residence, members of the Yoder family, Adam Yoder, Bill Yoder, Mary Yoder, and Kaitlyn Conley. And there's no artifacts of anyone using that Mr. Adam Yoder 1990 at gmail.com on any device except Kaitlyn Conley's phone.
We had like a casual discussion about if you download an app on one device, it's transferable to other things. Was there any evidence of that? Let me ask this: how did, if that evidence existed, how did she become a suspect after the fact? You know what I mean? How come she wasn't a suspect early on with digital evidence?
Well, until there was the search of Adam Yoder's vehicle, which yielded the colchicine bottle as well as the receipt, investigators did not even know that that email address existed. So once that evidence was discovered, then they traced back where that Gmail address came from, and then all the devices began the search for that email address. They didn't even know to look for that until that receipt was discovered. Right, because that receipt, in addition to having a name and an address, also has Mr. Adam Yoder 1990 at gmail.com as the email address associated with the account.
I want to make sure this is okay and not a legal issue. But we have, who just called in from Florida, who's listening online, is Mary Yoder's sister, and I don't know which side she's on here. Her name is Sharon Mills. Could we take her? Call?
No.
We'd prefer you ask us questions and not.
Okay. Well, can you grab the mic?
Okay.
Listen, we came on to address the things that have been said. I don't want to get into an argument with different people that have opinions.
So So this would be a sister that believes that Kaitlyn Conley is not guilty. Is that correct?
I believe so.
Okay. All right. Andrew, we'll take her, but not here. I owe you that, and I don't want to feel like I brought you guys in to ambush you in any means.
And just so you know,
especially you. I don't want you to think.
Right.
Yeah. Okay.
Just so you know, the woman that you have on the phone initially her theory was that her own sister killed Mary Yoder.
She thought, she said she called and was one of the first that called for an investigation that called the DA's office.
She did.
Okay.
She did.
All right.
And then she went on to another theory, which was that some person was out there killing doctors throughout the United States.
Okay. Well, I mean, she lost her sister.
Yes.
So I would think that people begin to get a little suspicious, and I guess we come up with theories, and you watch TV. I mean, you have a mourning sister here. I guess I
understand that, Bill, but you know what? The one thing I got to say about the Dateline special is, as Mike alluded to, it spent 1 hour and 45 minutes talking about the first trial.
I thought there was going to be a part two.
There should be a part two, and
yeah.
there should be a part two, and it shouldn't be on Dateline. It should be on Forensic Files.
Right.
This is a forensics case. There is no way in the world anybody could really make an opinion on guilt unless they look at all the evidence that's on Kaitlyn Conley's phone. Because unless you look at what the phone consists of, and more importantly, a backup of that phone, and consider the fact that once the backup was made, she actually texts Adam and says, hey, can you erase that, because she didn't want the backup to exist. She made it all the way through the first trial without us finding or seeing what was in the backup. And then when the second trial came, Stacey, because I added Mike to the team, Stacey was able to spend more time, and she was spending each night looking at thousands of things off the backup to see what she had erased. Now think about this for a second. If I was having a relationship with somebody, let's use a hypothetical. Stacey and I are having a relationship, and now my wife suspects it. Okay, I'm not going to erase all of my text messages to Mike Coluzza. but I will erase everything with Stacey. And it's quite interesting what Kaitlyn Conley erased. She erased anything that had to do with this, but she didn't erase all these other things.
Right.
So, that's an important part. And I think
if I can just ask here,
because finish one thing though, because I think something Laurie mentioned is so true.
Okay.
And I want to give you an analogy. If I was to buy a jigsaw puzzle today and go home, and I was to sit there and call you up and say, hey, Bill, I want you to do me a favor. I want you to tell me where these pieces are. And I was to describe those pieces to you over the phone, and you were never to see the jigsaw puzzle. Do you think we would be able to put the puzzle together? No, absolutely not.
Right.
And that's the problem when people make an opinion that don't look at the evidence. Because not only the evidence that was presented in court has lost its way into the public domain, because we're talking about 6 to 7 hours of testimony before a jury every day that's being reported on the media in 30 seconds to a minute at most.
Right.
So you can't fit it all in. Plus, you have a filter, the filter of the person reporting it. They might think something's important. They might not even realize something's important that we do. So what we are going to do is I am going to put Tony Martino's testimony, which was 2.5 days long. 2.5 days of one witness. That's unheard of. That's an incredible amount of testimony. And I know from somebody that spoke to a juror, I have not spoke to any of the jurors directly in this case, but I know someone who has, and that juror indicated to the person that I talked to that the strength of our case was 100% in Martino and the forensic evidence. So it's hard for us when people, and I listened to some people, actually I listened to one of the sisters, I think it was on your show, going on about how her son could have manipulated this. That's absolutely not true. And I guess the question I get, well, maybe we should have looked at him. I mean, here's the reality. They want everybody, not everybody, but the people that are trying to defend Kaitlyn Conley are trying to imply that somehow or another Adam Yoder could get his hands on Kaitlyn Conley's phone. Well, I don't doubt that, just like I can get my hands on my wife's phone.
Right.
But here's the problem. If you really believe that, Adam Yoder has to be the stupidest person on the face of the earth, because he goes through all of these. He goes to the point of using her phone. He uses a manner on the phone in which you can hide your identity on the internet. So whoever's doing it is intentionally trying to hide the fact that they're on the internet with, I think it's called a VPN. Okay. They also spoof their IP address. So great efforts were taken to hide what they were doing. And oh, by the way, he uses Mr. Adam Yoder 1990. Adam is gay is the password. I mean, a lot of those things make zero sense. Yeah. Because if you go
that was the password? We didn't know that.
Adam is gay is the password to that, okay? And I got to tell you, my passwords, I can guarantee you, are Scott's a fool. Scott doesn't know what he's doing. That isn't a typical password someone makes about themselves, because you don't think of yourself in that way.
So I guess my question, what I was going to get into, let's everybody, is what proof was there? And I guess you really have kind of answered that. What proof was there that she actually used the phone? Was the question, and that's really what you've talked about.
No proof anybody else used the phone, and I'll let Stacey explain it. But Policelli in the trial was very in Martino's face on cross-examination, implying exactly what you're implying, and dared him. I want you to go back and I want you to look at this. So it was literally lunch break. So we asked him to go back and look at it. And I'll let Stacey talk about what he...
Stacey, Scotti.
Yes.
So tell us what happened.
Well, what Tony Martino did is there's something called user attribution. And user attribution for someone in forensics means take a specific time period or a timeline and look at the other activity on the phone to try to narrow down who's using the phone. And when Mr. Policelli made those claims, it was on the lunch break, and we did have Mr. Martino go back. And there were all sorts of other conversations going on at the same time that it's fair to conclude, were not happening because of Adam. Kaitlyn Conley was having group messaging with her sisters, and some of the things that were closest to these searches were deleted. Not entire things, but the things closest in time to the searches regarding toxins and things that Mr. Policelli wanted us to look into. Those things were deleted. But there was other user attribution, Kaitlyn talking to her sisters, talking to her other friends, and talking about things such as her schoolwork and her final exams. And really the logical conclusion was Kaitlyn Conley was engaged in that activity, and she was the one in possession of that phone.
All right. I don't mean to, but Policelli would say there's still no proof that she even made those text messages.
I mean,
I mean, you could come to a logical conclusion, but there's still no absolute proof.
We don't need absolute proof.
I understand that.
It's proof beyond a reasonable doubt,
right.
And that's one piece of evidence in the case. But I mean, where is your cell phone right now, Bill?
It's sitting right in front of me.
Okay.
Yeah.
And where is your cell phone? Okay. And where is your cell phone?
It's around here somewhere.
Right. And mine is in my purse. For what Mr. Policelli is suggesting is that basically Adam Yoder had her cell phone like all the time.
Yeah.
And that's just ridiculous.
Okay.
I mean, nobody. My husband doesn't even have my cell phone on a regular basis. He may look at it on occasion, but I'm the one in possession of my cell phone. Now, take a 21 or 23-year-old girl. Really? Somebody else is holding her cell phone? They don't let it go for anything.
Right.
And if you watched her during the trial, she texted during the trial. She was on her phone during the trial, during deliberations, during lunch breaks, out in the hallway. It's her phone, and she's using it.
Right.
And the user attribution just backs that up.
So
the other thing,
Yeah.
Bill, to remember in all of this is that when you looked at the massive data that was on her phone, she was constantly using her phone. She was a prolific user of cell phones, as many of us are.
Right.
But you look at all of the activity surrounding the suspect communication, and ultimately what the jury has to do in a case is draw reasonable inferences from the proven facts. The proven facts are that this activity occurred on the phone and that these surrounding activities occurred.
So I want to go down this road then. First of all, in studio is of course Scott McNamara, the district attorney. This is the first time hearing from the prosecution since the trial. We certainly have heard from family members in the defense, Stacey, Scotti, Mike Coluzza, and Laurie, Lisi in studio. Am I okay to continue to not pay the bills here?
Yeah.
Okay. So what I would then ask you is if I've lost my question now after that.
Can I ask something?
Do that, and I'll have it again because it was a very important point that I want to make here.
What did you guys give me here? These are a couple of images. I don't know if these are drawings or...
Sure, those are images that came off Kaitlyn Conley's phone, and the one in your right hand is, I think, titled on the bottom of it, The Breakup. Mm-hmm. And, you know, sometimes the evidence we can't get in at trial speaks volumes of how somebody thinks. So when you look at things that people have, you can kind of look into their mental thought process. So in that one, as you can see, it is a female who has apparently stabbed the male in the back and ripped his head off. And it's entitled The Breakup. That's on her phone. She has a lot of stuff on her phone that doesn't coincide with this sweet little innocent young woman who could do no wrong. And I think the thing that most people not most, but the people that are supporting her, by the way, we're not going to convince them that they're wrong. Right. This is their loved one. And who wants to see their loved one go to jail for a long period of time? Yep. I get it. But the reality is, to the rest of the public, which, by the way, there's a small group of people yelling and screaming. And to be honest with you, I think a lot of it's being orchestrated by the defense attorney. And, you know, you have to understand what really went on here is that Policelli spent the whole first trial out in the hallway talking to the Conley family. Now, what he was talking to him about, I don't know. I can guess. I would suspect it had something to do with all the mistakes that Pelly was making.
Do you think that you're saying that was going on during?
I suspect.
Do you think he was undermining?
I believe that he was.
Because that's a pretty big charge here.
Well, I know what I saw in the courtroom every day, and he was out there talking to the Conley family all the time.
And then he became
and then all of a sudden he becomes the attorney. I don't know what the conversations were, but I know Frank.
Yeah.
And Frank is very opinionated. As a matter of fact, Frank was saying things to me then about mistakes he thought Chris was making or things that he would have done. I don't know. I don't know how much money the Conleys paid him. Okay? But let's be realistic. Okay? A lot of what's going on with him is he has to justify that he didn't deliver.
He didn't win.
And you know what? We know what he said in the back. He said, oh, great. He goes, now everyone's going to think Pelly's a better lawyer than me. So we know.
You heard him say that?
They did. They did. So what do you think's going on?
You guys heard that? Both of you heard that?
Yes.
Yes, yes, we did.
So think about
So
that.
do you think that Policelli is saving face?
No, I think he's trying to convince the public that somehow or another, A, it's a wrong verdict, B, somehow or another we cheated, we did things wrong. Some of the allegations he's made are beyond comical. For instance, okay, she took a polygraph test. She passed a polygraph test that, oh, by the way, he had administered. By the way, what he doesn't mention is she failed a voice stress test that the sheriff's department. None of that's admissible. It's not admissible in any court.
Both sides.
Right. It's not admissible in any court, and there's a good reason for that. Polygraphs are deception. They detect deception. They do not, fly up a red flag saying liar, liar. What they do is they show different things, how your body's reacting to a question. It is not science. And honestly, as a prosecutor, and I've been a prosecutor for 25 and a half years, I have never, ever used a polygraph test that I've requested. I have seen 4 people fail a polygraph test, ask the same question: did you kill Tom Lindsay? And 4 people failed it, none of whom we tried.
Right.
Okay, so I don't believe in them being very credible.
Is the voice stress test more accurate? Do you believe?
I don't think they're both deception
Okay.
things. They're police use them to interrogate people.
Got it.
And that's what they're used for. So
you would not use either one in a court of law.
I don't believe either one's credible.
Yeah,
And I'm on the Commission on Forensic Science, and when we put science into a courtroom, okay, it has to be something that is 100% credible. It's not something that you can somehow or another beat, trick, or whatever. And think about that. DNA, okay? If I had to take a paternity test for DNA, there is nothing I can do to beat that test. I can't trick the test. I can't chew gum and have my DNA change. I can't do anything. But think about this. Kaitlyn Conley actually researched how to beat a polygraph test, okay? Think about that for a second. Google it. How do you beat a DNA test? Is that out there?
Right.
No, because it goes to the credibility. And it's funny because the Innocence Project, Barry Scheck and a lot of other people are running around and talking about what they call junk science. Well, a polygraph is junk science. It's something that you can't rely on. And to be honest with you, 99% of the time, the polygraph test would be to our benefit to float into a courtroom.
Right.
It is not reliable evidence. So that's something that he's yelling and screaming. First of all, he would have to change decades of precedent.
I think we all understand that.
Okay, but he keeps saying that.
I
okay?
understand that.
There's another thing that he said, okay? Somehow or another, he was implying right after the verdict that the judge made a mistake giving the Allen charge. Well, let me tell you something. Had the judge done anything but give the Allen charge and that jury came back and convicted, the number one issue on appeal would be that the judge made a mistake and didn't give the Allen charge. I mean, we're tipping the world upside down here.
But what do you say, though, and I've heard from others say the same thing, is that you would send them back a couple of times before you gave or you don't?
You can't. The judge has to be very careful what he says so that it is not interpreted as being coercive.
Right.
So the Allen charge, which is 100 years old.
And he read word for word.
Yeah. And if you knew Judge Dwyer, that's Judge Dwyer. He does not get off. He does everything by the book. And and here's the funny part. Where's the outcry on the Allen charge? We've had 2 jury trials since this verdict. And both of those cases got an Allen charge.
Okay. I want to. By the way,
where's the outcry?
I don't want to lose my question when I reset you guys here, so that everybody knows who we're talking to as they're joining in, trying to slide down the highway this morning. Mike Coluzza, Laurie Lisi, and Stacey Scotti, and of course Scott McNamara from the DA's office, the prosecution in this trial. So here's my question, and anybody who wants to take it. Even you, Scott, if you want to take it, because I know you can't help yourself sometimes. My question, how do you get, if you couldn't get murder, how do you get manslaughter? Because you're basically, the case you're presenting here is that Kaitlyn Conley committed this murder. She intended to kill. If you can't get murder, how do you get manslaughter in this case?
Sure, Bill. I'll take that one. The law allows, and it's common practice, that in addition to the charge that is submitted to the jury, that the jury can consider lesser included offenses. And that's exactly what happened here. Now, the defense anticipated that we might do this. and the defense filed a motion seeking to exclude that. We filed an answering affirmation where we set forth our legal arguments, and the judge made the decision that it was proper in this case for the lesser included to be submitted. The interesting thing from our perspective is that the defense has repeatedly alleged that we changed the theory of our prosecution, or we constructively amended the indictment. The ironic thing in that is the only side that changed the theory of the case from the first trial to the second was the defense.
Right,
a 180-degree reversal, in fact, from Bill as the suspect
to Adam. Yeah.
Which raises the question, how can you sit through the first trial? If their narrative is true in the second trial, how do you sit through the first trial and attack Bill and point to Bill as the killer of Mary Yoder when, according to the narrative of their second trial, she's always known that it was Adam? How do you do that? But put that aside.
I totally agree. When that happened, I think I raised that point on the show.
And we did talk about that. And when that happened, did a bell had to go off for you guys?
Well, obviously we were scratching our heads about that. But let me just continue that. From the first trial to the second trial, our theory has always been that on the 20th of July of 2015, Kaitlyn Conley killed Mary Yoder by it causing her to ingest colchicine. That didn't change from the first to the second trial. From the first to the second trial, the argument about motive, which we don't have to argue motive.
Right.
That's a choice that we make, to argue motive, to help explain to the jury why this happened. The motive has always been the dysfunction in that relationship, the toxic nature of that relationship caused the defendant to want to hurt Adam Yoder. And this was the way ultimately she chose to do so. All right, so our theory hasn't changed. Now, the issue for us was, in looking at whether or not we request the lesser included offense, is the following. If a jury were to look at all of that evidence, and we can talk about individual pieces of evidence.
Yeah, I'd like to know the facts.
Sure. So if the jury, our feeling was, if the jury would looked at all that evidence and said to themselves, you know what, the people have proven beyond a reasonable doubt the physical act of poisoning. But we have a lingering, reasonable doubt about what her intent was, what her conscious objective or purpose was. Was it to kill Mary, or was it merely to make Mary very sick? If all they had to choose from was murder, which has a very simple laundry list of two things, intent to kill, did kill, they would have to acquit her.
Right.
And to us as prosecutors, the thought that jurors might acquit and walk Kaitlyn Conley out the door when they believed that she actually did the act of poisoning, we felt would be a miscarriage of justice. And for us not to request the lesser included as prosecutors would have been incredibly irresponsible.
Yeah.
So we chose, in fact, to ask the court to give the jury the option of the lesser included. Now, in order to, under law, in order for the jury to be able to consider it, first of all, it has to, as a matter of law, be a lesser included. In other words, you can't commit the crime of murder in the second degree without at the same time also committing the lesser crime of manslaughter in the first degree. So why is it a lesser included? It's a lesser included for the following reason. Killing somebody is the ultimate injury you can inflict upon them. It ends their life. But on the way to killing somebody, you're committing serious physical injury. So from our standpoint, it was appropriate that the jury consider the lesser charge that, in fact, in committing that act, that her intent was to cause serious physical injury. And the reason why we felt a reasonable juror, two reasonable people, might look at these facts and come to different conclusions about what the intent was of the defendant.
Yeah.
What, a person might, for example, she had calculations in her phone about what the lethal dose was of colchicine, 0.5 milligrams per kilogram of body weight. That was in her phone, along with a bunch of other personal stuff. One reasonable juror might look at it and say, "Oh, well, she's looking up lethal quantity. That's proof of intent to kill." Another juror might say, "No, wait a minute. She's looking at what the threshold is to make sure she doesn't go too far." So because two reasonable people could look at the same proof and come to different conclusions about what her intent was, while both believing that she had actually committed the act of poisoning, we felt it was extremely appropriate that the jury consider this lesser included offense. And the jury agreed with that and ultimately arrived at the verdict that they did.
Laurie, Lisi, pull it nice and close.
The only thing I want to add is that after the first mistrial, the judge talked to some of the jurors, and that was one of the things that they told the judge. You know, if we'd had an option of picking something lesser than murder, we would have considered it. And in fact, one of the jurors specifically told the judge, look, please communicate that to the prosecutors if they're going to retry this case again, that they should consider something else other than murder.
All right.
And I think something, too, that needs to be brought to light is this. In the first trial, we were prohibited from bringing in evidence of the fact that Adam got sick and that Kaitlyn Conley had given him the pills that he took.
That door was open, though.
Frank Policelli opened that door, and we could have flown a B-52 bomber through it, okay? And we did. And I think that also cut both ways because it kind of went to show who was doing the poisoning, but it also went to show that if they believed that she poisoned Adam, that she didn't kill him. And that created an issue with us where we had to think to ourselves, they could look at it and say, hey, maybe she's just really sadistic and she really gets off on seeing people close to death but not dying. And we would have been reckless to not have asked for the lesser included. And to be honest with you, here's the funny part. She benefited from it. And here's the thing as prosecutors. Our job is to seek justice. Jurors decide what the facts are. Sometimes we don't agree with them. But jurors decide. Yeah. Kaitlyn Conley benefited by us asking for the lesser included because we didn't put the jury in a decision-making position of murder or not guilty and then have them say, we're not letting her walk out the door. So they convict on murder when they didn't think there was enough evidence.
I want to talk. There is talk that there are some jurors that have talked, and I've heard one story from a source that says that the jury this jury member felt that they were coerced. Well, and let me just ask about that. You're in a jury room and you're debating. I'm assuming it is customary on a jury for one juror to try to convince another juror, or could we use the word coerce as opposed to convince? So discuss that a little bit, and then I want to talk about immunity. So start with that one if we could. Sure. Who wants to take that?
Well, first of all, the mere fact that 12 people have to agree to something, I think we can all just use our common sense. If you ask 12 people whether the weather was bad out today, you're not going to get 12 people to agree.
Good point. Yeah.
So you're going to argue about it. And so if you want to change arguing, putting forth your position, deliberating, and you want to change that word to coercion, I guess you can do that. But I think this is our system of justice, has been since our country was created, and it works. I think we get it, the juries get it right, and sometimes they acquit people when we think they're guilty, and obviously a lot of times they find people guilty that the family and friends don't think is guilty. So, I don't see that. I haven't heard that. We have to keep one thing in mind. The note that came out was 10-2 to convict for manslaughter first.
So
it doesn't seem like there's a lot of coercion going on.
Only two could have felt that way if that is
we
true.
Know from
we've heard others come out and say, well, it's the judge that intimidated them. Well, the judge went by the book.
If you read the Allen charge, the reason why he reads the Allen charge, it's a neutral charge. That's why Judge Dwyer will never go away from the Allen charge, because he's not going to be accused of that, the coercion point. But go ahead.
So how do you select the grand jurors to be witnesses, and why the immunity? Why? Because that is a sticking point. It was a part of the dateline. It's what everybody's saying. How could they have given these two immunity?
Well, first of all, we don't give anybody immunity. Let me explain that, okay? I've been the district attorney for over 10 years. I've been a prosecutor for over 25 years. I have never, ever actually give the old cross and said, you've got to.
But this is technically
this is how it works.
Right.
By law, by New York State law, if we call a witness into the grand jury, by operation of law, they get immunity if they testify and tell the truth.
Right.
Okay? That's the key thing. Okay? So I don't do that. It's not my idea. Okay? Somebody in Albany, and a whole bunch of people in Albany, years and years ago,
Right.
and I believe when our country was made, okay? So when people say that Laurie gave immunity or I gave immunity, that's absolutely not true.
I think that's
by
fair.
operation
I
of law,
understand
they get immunity. Now, let me explain to you how it works, okay? First of all, if you lie in your testimony, your immunity's gone. Okay, you only get it to tell the truth. So in reality, if you understand the complexity from our point of view, you got to be careful who you put in the grand jury. Okay, so I'll give you a fact pattern, and I apologize to my wife in advance, but it's easier just use myself as an example than anybody else, and I don't offend people.
You always
Let's say, for example, I was accused of killing my wife. Okay, and I did it. If the prosecution puts me in as a witness, and I go in and say the following: my wife and I were home, we were having breakfast, I left to go to the store, and when I came back, she was dead. And Laurie Lisi's prosecuting me. She says, Mr. McNamara, did you have anything to do with killing your wife? No, I did not. Did you kill your wife? No, I did not. Do you know who killed your wife? No, I did not. Those are all lies.
Right.
My immunity's gone because of that if I really did it. Here's where it becomes a problem from a prosecutor. You go in there and Laurie Lisi says to me, Mr. McNamara, do you know anything about how your wife died? Yeah, I'll tell you exactly what happened. We were having a fight. I really got sick and tired of her giving me a hard time. So I went up to my drawer, I got my handgun out, and I shot her in the head. I just got immunity because I told the truth.
Okay,
See,
interesting.
the immunity kicks in when you tell the truth and confess to the crime in grand jury. That's the reason for immunity.
Okay,
the reason for it is so that witnesses can testify truthfully in the grand jury without fear of prosecution. It is not to give immunity for lies in there.
So this might not be for you, but maybe it is, and you guys can pick this up. Why Bill and Adam? Why did you need Bill and Adam in the grand jury? You give me the look like you think I'm a giant idiot, and I'm okay with that. But and you're not contradicting.
You're not
that,
alone.
So.
No, I'm just kidding.
But I have no problem with that. I'll be okay at the end of today. I'll walk out of here with a head up, and I'm doing what I do. But my question is, why Bill and Adam? Why did you need them to indict Kaitlyn Conley?
Well, first of all, Bill was the victim's husband, and I'm sure people are going to want to hear from him. And he was with her in the morning, and then he went with her through when she got sick and when she passed away. And I wanted testimony about that. I needed someone to testify about their business practices, who has access to the office, when they have access to the office, to testify about the computers, how the computers are set up, how appointments are made, how the patients come in, what the work schedule is. So that would the logical person for that would be Bill. Adam, because by this point, when we went to grand jury, all the evidence pointed to Kaitlyn Conley, and in my opinion, the motive was Adam Yoder. Has always been in the first trial, second trial. Motive has always been Adam Yoder, and so I felt that the jury needed to hear about the relationship. And pardon the pun, but the toxic relationship between Adam Yoder and Kaitlyn Conley.
Does anybody want to add to that?
Yeah. The other thing was there was
pull it nice and close. Sir.
Sure. The other thing, Bill, was there was the note. There was a note pointing to Adam Yoder. Now imagine
the note. By the way, is without the note. None of this. We wouldn't be sitting here.
Without the note, we wouldn't be sitting here. That's the
I hate to do this. Just tilt that you're. Yeah.
I'm just worried I'm going to break your equipment here.
Feel free. Maybe we'll get new stuff.
I do it all the time.
Imagine yourself on a grand jury or a trial jury, and this note is out there, and the note points to Adam Yoder, and you know that the search yielded the culture scene from Adam Yoder's car. The number one witness you're going to want to hear from is Adam Yoder.
Got it. Okay.
Now, at this point, based on the evidence that we had, and at all times during this case, nothing incriminated specifically Adam Yoder. Adam Yoder, we were able to clear. The police were able to clear as a suspect. So, of course, we were going to call him a grand jury. Of course we were.
I want to finish. I have a minute here. And Mike Coluzza, Laurie Lisi, Stacey, Scotti, Scott McNamara, guys, thank you so much. I really appreciate it. But I want to just for a moment talk about human nature. Human nature is why we're here. In some case, absurd human nature caused Mary Yoder's death. But human nature, from our standpoint, from the public standpoint, you have Dateline, you have the defense attorney, you have the years of watching murder mysteries, and here we are, the public, saying, we question this. Don't take that in an offensive way. It's just us being human.
No, we don't, Bill. And I think in this case, unlike a lot of cases we try, we're going to put all the evidence on our website. We're waiting for her to get sentenced.
I'm very interested. To see
and I urge you,
yeah.
when it gets out there, please read the trial transcript, because I think when you do, we might not convince you, because I think when people make their minds up, it's hard to move them off that. But
I'm very indecisive.
You might see evidence that you didn't know was presented.
Guys, thank you so much. I really, really appreciate you taking the time, and I know it's not easy, and happy holidays, and thanks. So I hope to see you, Scott, next Friday for our Christmas show.
All right.